Our client is owed X amount of money. How do we get it from someone who's actively trying to keep us from getting it across jurisdictions? The goal is never to win a judgment. The goal is to get money back. And backward tracing is, in my experience, much more effective. And that's once you've established that there's been some sort of fraud or looting, then you can look, where is that bad actor today? What are they doing today? The borrower is almost always going to be the most friendly and the most willing to work with you from that first I can't pay you moment. I think everyone watches Suits or some other show and thinks that everything lives and dies by what a court says. And as I've explained earlier, so much of this happens outside of the courtroom.
This is the Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of the Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadeo. My guest today is a legal strategist who operates at the volatile intersection of global finance, distressed assets, and complex insolvency. He specializes not just in winning lawsuits, but in the intricate art of monetizing claims and tracing hidden assets across international borders. Bringing an engineer's precision to high-stakes legal matters, he spent over a decade in the New York trenches before building a globally recognized practice where he navigates everything from massive cryptocurrency bankruptcies to multinational fraud recovery. When not traveling to various courthouses throughout the US or meeting with clients and colleagues around the globe, he has called the Midwest home for the last 5 years, where he's a partner at Baird Holm LLP, a full-service firm based in Omaha, Nebraska. It's my pleasure to welcome Jeremy Hollembeak to the podcast. Welcome, Jeremy, and thank you for being here.
Thank you, Aniket. Thanks for having me.
It's my pleasure, Jeremy. So as you know, I love to start each episode by asking each of my guests to share either a fun fact about themselves or a cringe joke. Which will it be for you, and what is it?
I've got a fun fact.
Please.
When I was in college, I was in a rock and roll band. This was the late 90s, early 2000s, and we would play bars around the college town where I was, and some other places, like long 4-hour type sets. So we wrote our own music, but we also played a lot of covers, popular 60s, 70s rock. And after one show in Wichita, Kansas in December 2001, there was this gentleman at the bar between sets. He wanted to talk, and he was very excited about our music, and almost, I think, kind of annoying. I think at the time I probably, sort of nodded and then looked for an opportunity to move away. But skip to 2 months later, we had a website with a message board, and we had a post on there from this gentleman who was Hunter S. Thompson, the author and gonzo journalist. He was praising our music. He said that we really reminded him of a band from the 60s or 70s. And, I tried to follow up and run him down. The domain on the post was from an ESPN2.com domain that he was working at ESPN at the time. And I also don't think any of the other people in my band or our surrounding fan base were major Hunter S. Thompson fans. So I'm pretty sure it was authentic. And so that's my fun fact. I met and impressed Hunter S. Thompson.
That's amazing. So many layers to that, from obviously meeting and impressing Hunter S. Thompson to the fact that you had this band and you focused on, 60s and 70s. Was there a particular song that really was a crowd pleaser that you did or that you were proud of?
Oh, I always really liked playing Night Moose by Bob Seger.
That's awesome. Cool. Well, thank you for sharing that. That is one of the more fun facts I've heard, Jeremy. So thanks for sharing that. Moving on to the next question, which is that I think of every attorney who makes the time to be on this podcast as a superhero, and every superhero has an origin story, and I would love to learn yours.
Sure. So I grew up in small town Kansas, And I went to Kansas State University in Manhattan, Kansas, which was the Little Apple, as opposed to the Big Apple in New York. I ended up moving there eventually. But I got an engineering degree, but I never really took to it. I didn't really want to practice in it. So after college, I had like a gap year, and my then girlfriend, who I wanted to make my wife, we were in a bookstore one day, and I mentioned something about an interest in the law, and she said, well, you should check the LSAT books. And I pulled one from the shelf, and it indicated that the last day to sign up for the last test you could take for the LSAT in 2002 in order to enter law school in the fall of 2003 was coming up like the next week. So I signed up last minute, took the test, and ended up going to Hofstra University on Long Island 100% because my now wife wanted to live in New York. So we lived in a small apartment on Long Island for 3 years, and then I was lucky enough to get a big law job out of law school. There were some trying times, also probably the happiest days of my life. Between my first year of law school and second year of law school, I clerked for a judge of the Supreme Court of the state of New York down in Manhattan, downtown Manhattan. And then also my second year, I was a summer associate at a firm, Milbank, which was also downtown Manhattan. And from Long Island, I would, you could take a train ride, which was a long and expensive train ride, but I would often walk from our house to catch a bus all the way into Queens, to catch the 7 train all the way into Times Square, to take the 2 or 9 all the way downtown. It was about an hour and 45 minutes each way, but it was only a $2 subway token. So that really forged my story and my love of New York. And then the rest I'm sure we'll talk about. I worked at Milbank for 8 years out of law school, and then after that I went to a firm called Cobre & Kim, which at the time was very young, had been around less than 10 years, and was a global litigation boutique where I really learned a lot of great both legal skills and entrepreneurial motivation. And about 5 years ago, made the decision to come back to the Midwest. When you're going to courts all over the country, it really doesn't matter where your home base is. And so my wife's family is here in Omaha, and my family is all in Kansas City now. So it's been great, and also just I love the challenge of building, sort of taking what I learned in New York and building my own practice and my own brand here from Baird Holm.
That's awesome. There's so many threads in what you just shared there, Jeremy. So the snap decision to take the LSAT, your then girlfriend now becoming your wife, all moving to New York, and then the grit and the resilience that you showed in terms of taking the subway and taking this multimodal transport to get to where you needed to be. I think those are all incredibly wholesome and valuable lessons for younger attorneys. So thank you for sharing that. You mentioned the 2 firms that you were at while you were in New York, bankruptcy and litigation at firms like Milbank and Cobre & Kim. What did you learn there that you think shaped your trajectory for the future? That's part 1. And then part 2 is, what lessons from engineering, from the logical, rational thinking that one is at least trained to do as an engineer, do you think you applied at those firms and throughout your career?
Sure. So I think that at Milbank, it was very, I want to say big picture, because we got into some weeds and details on things, but I was thrust into working on, particularly, I started in the fall of 2006, and by the fall of 2008, the Great Recession was on us, and we were the busiest, most important group in the firm, and those were the horror story. I don't think that I ever crossed over 300 or 3,000 hours in a year, but I probably got close there for several years in the big law life. And so I learned how to work hard. I learned how to, but it was also very, the issues were cutting edge. So, you would get involved in bankruptcy related litigation over issues that hadn't been decided, or there were circuit splits, or there was something different about the facts of this one. And, it was a team, a gang tackle on most things. And I would say I learned the blocking and tackling of Chapter 11 and then eventually Chapter 15, bankruptcy, debtors, creditors, that sort of thing. When I got the bug for international work at Milbank after I did a couple of Chapter 15s, which is the chapter of our bankruptcy code enacted in 2005 that's specifically for enforcing in the US foreign bankruptcy cases and proceedings. And I knew that I loved the international aspect, so I gravitated towards Cobra and Kim. I was the first bankruptcy attorney that they'd ever hired. And Cobra and Kim specializes on more claims, asset tracing and claims monetization. So what I learned to do there was, it felt much more practical to me. The idea of, it's not just about getting a victory from this judge in this case, but a more concrete, our client is owed X amount of money. How do we get it from someone who's actively trying to keep us from getting it across jurisdictions? So that was very interesting to me. And then you transition to sort of Baird Holm. I'm in a different market segment, frankly, where I think here, the cases certainly at Milbank and to some degree at Kobe and Kim were hundreds or millions of dollars or more. Now more in a space that's like 10 to $100 million. And there it really matters. The clients are not willing to throw a team of attorneys at $1,500 an hour, $2,000 an hour to work on, some litigation that frankly is a bit academic. They just want results, and they want you to get those results for them in the least amount of, cost possible. So to pull that all back to my engineering background, I mean, chemical engineering is very much about putting things into an equation that everything fits into. And it was, in minus out plus generation minus consumption equals accumulation. And everything, whether you're talking about matter or energy, all fits into that equation somewhere. And when you're at steady state or you're in a zero sum situation, there's no accumulation. So it all equals zero. So whatever you put in plus whatever you generate has to equal whatever you consume, and then whatever's left is what you get out of it. And so I think that helps when I'm thinking about client cases. Is our goal is to get the most out possible. Are we going to put more in? Sometimes yes, sometimes no. Is the borrower or the situation that you're investing in going to be able to generate more money? Maybe if you put in more money, they can do that. And what is it going to consume? How much is it going to cost in legal fees? How much is it going to cost in risk? And ultimately, at the end of the day, that's how you determine what your strategy should be. That's how you advise your clients. So I do think that overlay of the more technical engineering background has been helpful. It also helps get rid of a lot of people can get emotional around distress. Our clients aren't getting paid. They can be very upset with a borrower who's lied to them, or really want to stand on principle and go after money that just isn't there. So part of what my job is as a counselor is telling clients, this is what I think you can get out, and this is how we can get to it. It is very cut and dry sometimes.
Thank you for sharing that, Jeremy. The equation there was something that was a really nice way to describe, to merge these two or bridge these two worlds of engineering and law together. And I can speak on that with a little bit of authority because I too was a chemical engineer many moons ago. And it's been at least 20 years since I heard that equation, and certainly the first time in a legal podcast. Yeah. Thanks for sharing that with the audience. You mentioned claims monetization, and you touched upon a little bit of that. Can you maybe, for the attorneys in the audience, can you explain how, thinking from the mindset of monetizing a claim differs from hey, just winning this piece of litigation? And what's the mindset shift that's involved there?
Sure. So I think it helps when your clients are people that you can meet and see, and they're people that are integrated into, an economic environment that feels tangible to you. I'm not saying you can't do that at a very, macro level where all the white shoe firms exist, but it's certainly from my experience is easier in these real world contexts. And so I have involuntary clients or clients that are involuntarily in distressed situations, meaning they lent money or invested into a situation when things were good and they expected to get out of it on their contract terms and at their contract rate of return. I have other clients that are intentionally getting into distressed situations, private credit clients, distressed hedge funds that can have something to bring to the right type of distressed situation where they believe they can get more out of it than the existing creditors can. But in either case, the goal is never to win a judgment. The goal is to get money back or to enhance an investment so that maybe it remains in the client's portfolio, but it's on much better footing. But almost always it's ultimately to get money back. And so when you're focused on that, and over time, the experience that I've had has shown is it's not about what happens or can be done in court. It's frankly a lot of it's done before you would ever get into a court, and a lot of it's done in negotiations over, if you don't do this, then I know I can go to the court and have get this kind of order without ever having to do that. And those are the best cases, frankly, where you can sort of get what you want without ever having to go to court. So that's been the difference, really. I still consider myself and that process very much a litigation process, and myself a certain type of litigator. But as I frequently, tell my colleagues in my more pure litigation colleagues that, okay, well, we're going to court, but if this thing gets past a motion to dismiss and we got to start, deposing people or putting people on the stand, I'm having you do that. I'm the bigger picture and strategy guy. So, I hope that answers the question, but I think that's the type of litigator that I've found my comfort zone.
No, absolutely. Yeah, it makes sense, right? Because ultimately, I would imagine that the clients are coming to you, whether voluntarily or involuntarily, as you mentioned, because they want a certain matter resolved. They effectively want their money back, and if you're helping them do that, then and if you can avoid the litigation, then that's great. And if it still needs to go to litigation, there are other attorneys who can handle that. So that does make a lot of sense.
Right.
Moving to specific examples, and then moving to something you said in your introduction, which was around your interest and your work in the international space. So your bio highlights this fascinating case about a Brazilian retail company that was quote unquote looted by former owners, and there were some assets that were hiding in Miami and so forth. Can you walk us through sort of what that looked like, and how do you trace assets in a cross-border scenario, and just how that whole matter panned out?
Sure. And I'm going to take that in kind of reverse order, because following on from what I was just saying in the last question, I want to explain that there's a very important difference in the way that you can trace. There's many specific ways, but let's just generalize into two ways: forward tracing and backwards tracing. Forward tracing is when you get a judgment, usually, or just really strong evidence of some kind of illicit transfer, whether it was intentionally fraudulent or just, a transfer of assets out of the reach of you, the creditor, who should be able to look to them when the borrower eventually doesn't pay. Then you take that and you just try to trace where did the money go, and you have to start with where it went first out of the account that was within your jurisdiction into some other country or some other account somewhere, or maybe it's not even money, maybe it's some kind of physical asset, but it was moved. And you just have to keep doing that until, if that's your only means of recovery, you're going to have to find that money where it's in some place that you can keep it from moving out, and you have proof already obtained that it goes all the way back to your original illicit transfer. That's forward tracing. And that's very difficult, because if you're talking about an international business as a borrower, or a high net worth individual that has a presence in many different jurisdictions, to avoid collection, all they have to do is stay one step ahead of you and just, move it to the next jurisdiction or the next account. The other thing you can do is backward tracing. And backward tracing is, in my experience, much more effective. And that's once you've established that there's been some sort of fraud or looting that's taken place in a business or a situation, then you can look, where is that bad actor today? What are they doing today? And how are they, invariably, when you find out the answer to that question, they're living well, somewhere that's very nice that you wish you lived. And how are they funding that? And then you go after the assets and the accounts that they have right now today, and you try to trap that and cut those off. And then all of a sudden you've got their attention, and you're not trying to trace back, years of assets and transfers to get there. So that's sort of backward versus forward tracing. In this case that you mentioned, there was an individual who had taken over a chain department store in South America that was very popular for many decades. And then within a short amount of time, it went bankrupt. And, lo and behold, he had pulled a ton of the money out for himself and had placed it in Brazil in, the name of, opened a bunch of different entities that were kind of shell entities, but they were all owned by not him, right? Like family members. There was even like the gardener owned one, that sort of thing. And, if we'd had to go and prove that money went, was back at the department store, had been at the account of the department store years earlier, that could have taken a long time and been ultimately unfruitful. But what we discovered was, he was living in Miami, and that we had a private investigator take a look at him, and just the number of companies that he was listed as owning or the agent for on public Secretary of State websites. The Florida Secretary of State has a very open public registry, and then all of these entities were listed as owners of various. There were a lot of cars, like a dozen different fancy cars, Bentleys, that sort of thing. He belonged to a country club that we saw him going to frequently, and he was going to the ATM frequently to get cash. And so the department store was in bankruptcy in Brazil. And what we did is we opened a Chapter 15 on behalf of the bankruptcy trustee in Brazil in Miami. This is when I was at Cobra and Kim. But at the same time, on the first day, we filed emergency ex parte motion to get bank discovery, and we're able to get an order from the court and issue a subpoena to the bank and have those bank records in our hands 48 hours later, before this individual, I think, probably had been served, or he'd been served, but before he had a chance to really show up and try to stop it. And then we had an enormous amount of leverage over him, and we're able to then use that, to say, you have this wonderful lifestyle. You want it to go back to the way it was. You need to pay up. And, oftentimes that's really when you can settle a case at the very beginning. So that's that story. And that's an example of what I'm always trying to utilize backwards tracing as much as I can.
That's fascinating, Jeremy. Yeah, thank you for the primer on forward tracing and backwards tracing. And then also the example that you shared. I mean, this was not that long ago, but it seems like it could have been in any era where you just kind of hire like an old school private investigator, identify that this person is living likely outside of their means, and then make the connections or whatever connections you can between this individual's lifestyle and this entity that is going bankrupt. So that is a fascinating story. Thanks for sharing.
Yeah.
Moving on to another example of a distressed asset or a bankruptcy. I understand that Genesis Global Capital is in the crypto field, and that there's a bankruptcy going on there. Can you maybe walk us through that, including the implications of this being in the crypto space, being on the blockchain, and how does asset tracing, both the forward and or the backward, how does that work when you have the blockchain being involved?
Yeah, so my involvement in that case, I represented the largest altcoin creditor, who ended up being on the creditors committee in that case. There was not a lot of asset tracing involved in that particular case. That was more symptomatic of the crypto winter thrusting a whole lot of these platforms, obviously FTX being the biggest and most notorious, but there were certainly many others, into bankruptcy, and the sort of mass confusion and disruption that was caused, where I think a lot of people who had put their digital assets on these platforms were doing so under the impression that those were their assets. And so even if a platform went into distress and went into bankruptcy, they could just get their digital assets back. And what was, they almost all of them discovered to their chagrin was that that was not the case, that these platforms were operating very much like deposit banks, and under their customer agreements, which they probably didn't read, they had transferred ownership of the digital assets when they were on deposit, such that those platforms in bankruptcy, all of the digital assets that were on platform for most of these customers anyway were converted into US dollar claims as part of the bankruptcy process. And that's, Chapter 11 is a one-size-fits-all, but it certainly fits some better than others. And there's a strong argument that the crypto cases exposed a weakness or a hole in the bankruptcy system as it applies to crypto. And there's been the Genius Act that was passed last year, had aspects of it which were meant to address that. I'm not sure that they will, but that was an interesting foray, and it's just something else that I do in addition to the asset tracing. But I do have experience with chasing assets on the blockchain. I think there are common misconceptions. I always find it interesting, like the NBC reporter's mother who's been kidnapped and is, when the ransom note came up and they said deposit crypto, I thought, they don't know what they're doing. And, anyone who is going to get paid in crypto, is there going to be a complete blockchain of how they got paid that's secretly traceable. That's one of the advantages of crypto and blockchain. The disadvantage is it's anonymous, and the other disadvantage relative to just tracing assets through bank accounts is you don't always know where the assets are. You don't know how to access the wallet or the person that owns the wallet, even if you find out who that is. So you're left trying to capture those funds when whoever owns the wallet tries to move it. They're different wallets, usually through an exchange. That's a choke point when you can sometimes capture that money. But it definitely presents a challenger. It's different. I wouldn't say it's necessarily harder, but it's just different.
Makes a lot of sense. Moving to another aspect of the international work that you do, Jeremy. So you specialize in something known as Section 1782 applications, which is effectively using U.S. courts to get evidence for foreign proceedings. And so can you maybe speak a little bit to that? How does that work? How do you use essentially U.S. discovery power to crack open a case that might be happening on another continent?
Sure. So I think it's important background to understand that the U.S. legal system, and particularly the federal rules of civil procedure, have the broadest discovery that's available in any legal jurisdiction in the world, so far as I'm aware. And that's on purpose. And a lot of discovery in civil litigation is done without the court's involvement. The parties have obligations under the rules, and for the most part, they get followed. If they have disputes, they can go to the court. That is a almost crazy idea to many lawyers in many other jurisdictions around the world, where the legal system, whether it's because they're civil law as opposed to sort of a common law system like we have in the US, or for various reasons, the ability of one claimant or litigant to get documents and information from the very people that they're trying to sue to get, money back or a judgment or whatever, is a very foreign concept, no pun intended. So So 1782 is a way, and it has guardrails. It's not always applicable, but when it is, it's a way for litigants involved in or about to be involved in litigation outside the U.S. to come to the U.S. and get certain types of information to support those proceedings in another country in a way that they would never be able to get access to that information if they had just stayed in their own country. And for my practice, what it's usually used for is to get banking information, because the U.S. is the financial center of the world, and a lot of money flows through banks that at some point, the transactions involve U.S. dollars, and so they have to go through, even if it's a foreign bank, it'll have a U.S. arm or subsidiary that does its correspondent banking for U.S. dollar denominated transactions. So I file a lot of these applications in New York to get basically banking information to show flow of funds. And a typical example would be when my client is involved in trying to, maybe they bought shares and they're a minority holder in a company, the owners of which are maybe involved in something illicit or are looting the company. Then they can come to the U.S. and get bank discovery to provide evidence to that back to the court in their home jurisdiction where they're going to sue, or maybe to a regulator in their home jurisdiction if they're going to try to have maybe a securities investigation or a corporate investigation or an antitrust investigation. So that, and I've definitely been in situations where, like, once we finally, it was a hard fought battle, once we got the bank discovery, that was it. Like, that's all we had to do. And then the other side was willing to sort of settle everything and make a large payment. So, it's an incredibly important tool. Its intended use is to support litigation in other countries. I found that it can even sometimes be its own end in the right circumstances.
Yeah, thanks for sharing that. That sounds like it, certainly. So, one example, it sounds like, from what you just shared, Jeremy, is that if somebody's in a different country, they could potentially reach out to you, and Section 1782 leverages the fact that there might be some US dollar denominated transactions that came through the United States, even though there was no real physical operations or anything else related to the United States. But you could use that, or the attorneys in the third country could use that to sort of prosecute whatever they needed to do on their country, with no other connection to the US other than the US acting as an intermediary and the power of Section 1782.
That's right. Yeah.
That's incredible. Switching gears a little bit, so in the world that you work in distressed debt and claim monetization, speed is often value, right? And so, with technology, being a major driving force in all sorts of different things, whether it's high frequency trading or AI, claiming to bring huge efficiencies and benefits at a much higher pace. Where do you see the role of these advanced technologies, specifically AI, in terms of analyzing maybe a docket or a portfolio of investments, and maybe potentially giving certain parties an edge in either the matters that you work on or even in the markets?
Sure. I mean, so in terms of analyzing markets for distressed investments, or assets that might go up through a restructuring process, something like that, I think that takes place largely on the investor side. By the time certain things hit dockets, bankruptcy dockets or other dockets, I'm in a much more reactionary position. But I think AI is going to be incredibly helpful in that regard. Where I could see it helping, it's not there yet from my perspective, but are the cases where the borrower is engaged in some sort of fraud or fraud adjacent. Fraud's a word that gets thrown around. If you're talking about proving someone's a fraud in court, that rarely happens. But if you're talking about a borrower who says one thing and does another on a spectrum of little white lie to hiding assets intentionally, or double counting collateral, whatever, that's something that's present in many, many cases. And, the US legal system is largely very public. And if your borrower or target is involved in any kind of litigation or any bankruptcy, and that includes any of the entities that they might own or control other than, completely separate from your borrower, but nonetheless, tied to the same person, there might be very helpful information out there about that. And I have spent hours and hours and hours before just poring over dockets, connecting one case to the next case to the next case. And so AI could certainly help with that. It also helps with, like, I've had cases that hinged, the ultimate result hinged very much on bank records, which I would obtained through through discovery, or basically voluntarily the debtor gave them to us, but it was a quid pro quo for forbearance on debt. We weren't going to enforce for so long, but they got to give us all the bank records. And then just connecting, okay, the money, we lent money, it went into this account, then it went to this account, then it went to that account. I would love nothing more than to have been able to, just take those bank records that I had and slot them into AI and say, connect all the dots for me. It's very difficult. From one account to the next, sometimes the numbers aren't the same. Sometimes the memo line's not the same, and all the information you have is, an abbreviated word or letter. So I've not, frankly, even tried that hard yet to set up into our licensed AI software a series of prompts that would get me there. But that's coming, and that will be very helpful. I don't think that it's ever going to overtake a very important ingredient in the situation, though, and that's just like human intuition and experience. You just have to have a nose for it and know. And the one thing I was talking about in particular just now, tracing a lot of the bank records, eventually I went from the money that our client had lent through several other accounts into a account that was in the name of an entity that owned a yacht, a nice yacht. And then that led down all different avenues, and that became its own sort of source of leverage, because it's like, you can't pay me back, but all the money that I gave you, which was, intended for construction, went, a lot of it to and the information that's out there. I don't know if I printed this off. This was the Facebook page and the wife of the borrower, and there's the yacht.
Oh, wow.
And I was able to access this. I'm not a friend of that person, obviously. So, they didn't have a private, the privacy slits switched on to their Facebook account. So it's little things like that I don't, it'd be amazing if AI could pick up on that. But I think I'm looking forward to using AI to shorten some of those hours of looking at this and that. But it's never going to be completely autonomous, I don't think.
Makes a lot of sense. Yeah, that's certainly a take that I completely agree with. Is that if you've built the institutional knowledge, the intuition, it's an enhancer and an accelerator. It's not a replacement. And that example of using your intuition, where sometimes technology is interesting, right? Like social networks or social medias where people just volunteer up some of this information, and it sort of can work against them, as it did in that individual's case. So that's fascinating. Okay, so if we now think about the kinds of clients that you represent, and imagine a situation where there's a deal and it goes sideways, and now you have a borrower that's entering distress. Given your knowledge and experience, what is the single biggest mistake that you see that lenders make, say, in the first 48 hours of that happening?
That's a great question. First of all, if they find out a borrower is not going to repay them, like, for the first time, and that's on the date of a payment, and there's it's hard to map that 48-hour period. The biggest mistake that many clients make, oftentimes before they come see me, is they're not anticipating that their borrower might be in default, and sometimes that's just paying attention to the macroeconomic environment. And sometimes that's just, you've got to make a cost benefit analysis as a lender or an investor. But if you can, you want to stay in touch with the borrower between payments, understand how they are, what they're doing. And, if you're diligent at that, it shouldn't be a surprise when all of a sudden, they're supposed to pay you and they don't. But if we assume that we're in that situation, then the next mistake that clients usually make is they start off too. I think they know they're not going to get money right away, and they're just a little bit confused with the situation. They're too nice, frankly. And I don't advocate being adversarial right away, but what I mean is the borrower is almost always going to be the most friendly and the most willing to work with you from that first "I can't pay you" moment. And it's going to go down from there over time. And things almost always get more adversarial. So you as the client are the best thing you can do is establish a framework right away, put together a forbearance agreement, which is my sort of bread and butter, which just says, okay, you're not going to pay me now, but you're going to pay me, and whatever those conditions are, you're going to in a month, a year, whatever. And in the meantime, you're going to do X, Y, and Z, and you use that agreement to close all of the loopholes, to force the borrower to release and waive any claims that it might have against you, so that it can't, not pay you for a year after it was supposed to, and then start trying to allege that lender liability claims or things like that. You want to get as much as you can right up front. The case I just talked about with the yacht, I got those bank records because it was the first thing I asked for when we were all being friends, and we all got on the phone with his lawyer and me and said, oh, I'm sure we can work this out. And I can tell you that from that phone call to the day that we ultimately got paid was 13 months. Even though that first phone call, we were talking about, a 45 to 60 day timeline. So in those first 48 hours or whatever, when it initially happens, put a framework in place that you can be adversarial under later if you need to, and get as much information as you can, extract the promises that you can.
That's such a fascinating insight, Jeremy. Thanks for sharing that, because, I don't think, I certainly didn't, and I'm sure many of our audience doesn't really think about the fact that, hey, that first call when they say "I can't pay you" is the best that the relationship is going to be. So knowing that upfront and then planning for however that trajectory might go, which typically, as you mentioned, it becomes more adversarial later on. That's a great piece of advice. So thanks again for sharing that, Jeremy. This has been a great conversation. Just a couple of quick questions to wrap it up, or maybe not quick. We'll see. Going back to your, what you shared about your practice being international and all the different things that you've done. You're an Insol fellow. You deal with jurisdictions all the way from, the UAE to Mexico and everything in between. And obviously you've had a couple of decades of experience, doing what you do. And so now for a young lawyer who's looking to build a cross-border practice similar to yours, what guidance would you have, not just in terms of, understanding the laws that they need to understand or figure out across the jurisdictions that they're looking to work in, but also the culture of the various countries and regions that they're looking to work in?
Yeah. So I think it's incredibly important to, if you want to be in this field, to spend some time and effort on a comparative law type education or study. I did the Insol Fellow Program, which is a year-long course where you go through and you are literally learning about the different insolvency laws of the major jurisdictions around the world, and thinking about the differences. And of course, you could do that for any kind of law. It's important to understand that, the laws are solutions to legal or political problems, and there's not one right answer for the whole world. So I think it's incredibly important to understand how another country or jurisdiction, why it has the laws that it have, and the differences, why they're important, and how you can respect them, and how you can ultimately use them if you have to put together a cross-border strategy where you can get different things in different jurisdictions. And then in terms of, advice for for people coming out of law school or just wanting to get in this practice. There's no substitute for you. You have to be somewhere that has a practice like that with people that have established practice. And then, you just have to make contacts and keep those contacts up. I've had great fortune with business development just because I keep in touch with people. I'm that guy, for every one time somebody emails me, I probably reach out to them 6 times. I'm the one who, at the next conference is setting up the, get together so that we can all, we all benefit, we all meet, but obviously I do as well. And I was literally just today emailing with someone who was a former colleague with at Milbank, who now is working for an offshore firm in Hong Kong, and some of her colleagues in the Cayman Islands about a potential, my involvement in potential Chapter 15 here in the U.S. That wouldn't happen if I wasn't, still trying to stay in touch with, people that I last worked with in 2014. So, you have to find somewhere where you can get involved in that kind of work, and then you have to forge relationships.
That's great advice. And in today's day and age, you can do that even from the Midwest as you are, which is amazing. So you build your relationships globally, but you can work and live essentially wherever.
Yeah. And when I go around to law schools and I'm trying, with our hiring committee or whatever, I'm saying, if you want that kind of a career, but you live in the Midwest, I'm not sure that there's a lot of other places you could go and get it. If you want to go to work in New York, then you should go to work in New York. It's great. But I'm very proud of being able to do it, from here in the middle of the country, in flyover country, according to some people. So.
That's great. We're right now in just a fascinating, is one descriptor, I guess, economic cycle, high interest rates, liquidity crunches, all sorts of things happening around the world right now. And so, for the investors and business leaders who are listening, what are some things you're looking at right now? And again, it's a very volatile situation, but what is something you're looking at right now that tells you, hey, this is where the next wave of potentially distress or opportunity, depending on, involuntary or voluntary, as you mentioned in the beginning of our conversation, where is that coming from? What are you looking at?
I mean, it's something that I became desensitized to in some senses, because when I first came up as a lawyer 20 years ago, the sort of old timers then, it was, every 10 or 15 years, there's a down cycle and we get really busy. And then that seemed to play out for me in the Great Recession. And I was very busy from, 2008 to 2013, let's say. But then there was this incredible period, the 20 teens, and even in, and COVID was its own thing, but, even into this decade that, there's just been a long time without a, real strong down cycle. And so I kind of became desensitized to sort of trying to predict when the next one was going to be. I just said it'll come when it comes. And frankly, I've shifted enough of my practice to fraud, which doesn't always have a cycle. I mean, there's just, good times or bad times. There's people that are engaged in shady business dealings. But, if there is a factor that I think means more than others, it would be probably real estate values. And that goes across the, the board, from residential to commercial and in the Midwest here, ag values as well, in the agribusiness, the, farmland and stuff. Because what's happened is there's been a long period of appreciation of land values, and that became the collateral with which more and more money was borrowed, and debtors became more and more leveraged. So whenever there comes to be a sustained period of time where land values, aren't going up or even go down, I don't see how that doesn't cause some significant distress. And then, the second, I think, would be interest rates. I've already been on deals that have gone into distress, and we're having to figure out plan B, because plan A was we're going to complete construction and add this much value to the property, and then we'll be able to refinance our way out of it. And, that was built on an assumption of interest rates from 2023 or 2024. And it just doesn't, the rates today don't support that. So no one's going to be willing to lend enough against this asset to take us out. So those are the two I would look at.
No, that's great. Thanks for sharing that, Jeremy. Yeah, because I mean, wasn't 2008 all about, hey, house prices have nowhere to go but up, so let's kind of keep layering it on until it all.
Yeah. I mean, it's definitely not a novel revelation. It's kind of the same old story, right? But but we forget it. I think over time.
For sure. Final question for you, Jeremy. Is there a question that I should have asked you but I didn't?
I think that I probably started talking about this at some point. I mean, I think that the question that I think there's what do people most misperceive, the general public, about litigation in general, or even specifically claims monetization litigation, the kind of litigator I am. I think that's an insightful question, because the answer is that I think everyone watches Suits or some other show and thinks that everything lives and dies by what a court says. And as I've explained earlier, so much of this happens outside of the courtroom. That's where 95% of the successes and failures happen, in my experience. You rarely are ever hanging your hopes on a court entering a certain order of judgment. And even if you are, getting that order of judgment rarely gets you everything you want. Then you have to go out and enforce it. So I think that's the question that you could have asked, I guess.
Sounds good. Well, thank you for sharing that, Jeremy. And thank you again. I mean, this has been a wonderful and insightful conversation. I certainly learned a lot, and I'm sure our audience did as well. So thank you again for your time and your insights.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.